welcome everyone here this morning, and particularly thank Brett and OPC IT for this initiative and allowing me to be the first talent to address what will hopefully be an ongoing exchange, and to also commend OPC IT for the huge amount of effort they put into getting this morning organised, and to thank them in particular for their hospitality. As Brett has indicated, I am speaking to you this morning on powers of attorney and appointments of enduring guardian. Now, it's only human nature that I know that you'll be sitting there thinking, well, this is all very good, Mark, and I know a little bit about this, or I know a lot about it, but how much is it all going to cost? What I do in that respect is to ask you to consider putting in place an appointment of enduring guardian and an enduring power of attorney, if you have not already done so, as an investment. I'd also like to just share with you that I have an adult daughter who lives and works in Canberra, and she and her boyfriend have just moved into an apartment in Kingston Foreshore. In Kingston Foreshore at the weekend is a place which seemingly crawls with people in lycra and people exercising their dogs. My daughter and her boyfriend have the bikes and the lycra, but they now think that they should have or need a dog. I just happened to be in a retail pet outlet in Goulburn about a month ago, and there were advertised for sale, and the product was there on the floor. Puppy beagle ears, which are, for those of you who don't know, a cross between a beagle and a cavalier. And these pups were going for $1,495. Now, I'm not passing any comment on whether that's value for money, a good buy, a bargain, or what. All I'm going to suggest to you is that you consider one of these beagle ear pups as a unit of measurement. And if the pup's got 4 legs, then I'm going to be suggesting to you, or telling you throughout my brief address, that given that the pup's got 4 legs, then if we can equate one leg to approximately $350, then that will be the unit of measurement that I suggest that you use when I'm talking about powers of attorney and appointments of enduring guardian. So, powers of attorney. What is a power of attorney? A power of attorney is a legal document in the form of a deed made by one person, who is called the principal, that allows another person, or more than another person, 1 or 2 or 3, to do things on behalf of the principal. The person who is appointed and who does the things on behalf of the principal is known as the attorney. Now, there are 2 types of powers of attorney. There's a general power of attorney and an enduring power of attorney. I would particularly like to talk this morning about enduring powers of attorney, but for the sake of completeness, I'll just briefly speak about a general power of attorney. A general power of attorney is a power of attorney that you can make whereby you appoint an attorney for a specific task or for a specific period of time. For example, you might want to appoint an attorney to look after your legal affairs or your financial affairs whilst you proceed overseas for a month or 2. Or you might want to appoint an attorney for a specific transaction, for example, to sell a house or to buy or sell a motor car on your behalf while you perhaps are going to be in hospital. Now, an enduring power of attorney is a power of attorney which enables the attorney to do things on your behalf, but which continues to have legal effect after you, the principal, loses mental capacity. Now, when you make an enduring power of attorney, it's possible to stipulate, indeed one must stipulate, when it is to commence. Now, the options as to when the enduring power of attorney commences are: once the attorneys have accepted his or her appointment by signing the document, once a medical practitioner considers that I am unable to manage my affairs, or once my attorney considers that I need assistance managing my affairs. So it's therefore possible to make an enduring power of attorney, and I'm urging you all to, if you do not have one, to make an enduring power of attorney such that should you lose mental capacity, then there is immediately someone in place who can look after your financial and legal affairs. Up until you losing your mental capacity, then you are in control of your own affairs and you have lost none of your rights. So therefore, it's possible to, later this afternoon or this week, make an enduring power of attorney, but still be in control of your own affairs because you have not yet lost mental capacity. Meanwhile, should you have the good fortune to be having a month or two overseas, you can appoint an attorney under a general power of attorney just for the specific period of time that you are away. Because as soon as you lose mental capacity, you cannot make either a general power of attorney or an enduring power of attorney. So it's very important to have in place the power of attorney, an enduring power of attorney, as soon as possible. Someone's got a question?
Yeah, just on that, if by chance you do lose your mental capacity and you haven't got a power of attorney in place, is it possible for someone to take control to be a power of attorney without that person's permission unbeknownst to him or her? i.e. a family member?
No, it's not. In other words, if you have not made an enduring power of attorney, you then lose mental capacity, then it's not possible for someone to step into the breach just like that.
So not
It is possible. What one needs to do, and I guess I didn't want to even share this with you because, you know, for the sake of one hind leg on this pup about which I spoke earlier, to put in place an enduring power of attorney now just does away with all the unnecessary stress and cost that not you but your loved ones are faced with come the time. It is possible to go to the courts to have a financial manager appointed, but that takes time and it takes considerably more money than a hind leg on this pup. So does that clarify the situation?
Yeah.
Mark, may I ask you a question? So where does your spouse play in this whole? Your partner, your wife, your husband?
Well, when one makes an enduring power of attorney, one should, it's usual for a married couple to appoint one's spouse. A spouse does not automatically step into the shoes of an enduring power, an attorney appointed under an enduring power of attorney. So that's a good point. Your spouse cannot just automatically pick up the ball and run with it if there is not an enduring power of attorney in place.
Excuse me. If you already have a will and trusts in place, Do you still need a power of attorney?
Yes, I would urge that you do put in place a power of attorney, because the will and the testamentary trusts embodied in that will only come into place or into effect on your death. An enduring power of attorney and an appointment of enduring guardian, that I'll get onto in a moment, come into place while you are alive, should you become incapacitated. So when to make a power of attorney, as I've just explained already, you need to make it before you need it. That is why I'm suggesting that you make it straight away if you don't have one. Now, who can be appointed as an attorney? The word attorney, when used in this context, does not mean that the person appointed needs to be a solicitor or a lawyer. It can be, but it does not have to be. The person appointed can be anyone over the age of 18 years. And obviously that person needs to be able to assist the principal with money or property matters. It's usually your spouse or a relative or friend, or as I mentioned earlier, it can be a professional advisor. The attorney must not be bankrupt nor insolvent. It's obvious that the attorney should be someone who the principal trusts, both now and in the future. In other words, the principal must or should be comfortable with the knowledge that this person is not going to do the wrong thing by them, should the circumstances arise whereby the attorney is in charge of the principal's financial and legal affairs. Now, it's possible to appoint more than one attorney. Indeed, it's a good idea to, if not to appoint more than one, then to certainly appoint a substitute, because what you don't want to happen is for your attorney to predecease you or become incapacitated themselves, and for you, when you then become incapacitated and lose mental capacity, for the document not to have any effect. So consider seriously appointing two or a substitute. What most married couples do is appoint their spouse and then, as a substitute, appoint an adult child. I've mentioned already the loss of rights under a power of attorney and enduring power of attorney. You don't lose your rights to operate your own bank account and transact your own shares and deal with your own real estate while ever you have mental capacity. It's only after you lose mental capacity that the enduring power of attorney would come into effect. Now, what can the attorney do? As I've alluded to already, the attorney can access your bank accounts, they can buy and sell your shares, they can buy and sell your real estate, or they can enter into a mortgage on your behalf. They cannot make health and lifestyle decisions. That is why in New South Wales there is this second document, which is a complementary document, which is the appointment of enduring guardian. Now, anything that the attorney does under the power of attorney, provided it's legal, is binding on the principal. So if the attorney lawfully enters into and signs, for example, a mortgage on behalf of the principal, the law will see it as the principal having signed the mortgage documents, and so the principal will be liable to repay the mortgage, not the attorney. There are some things which an attorney cannot do, and two examples of that is an attorney cannot vote for the principal, and also an attorney cannot perform the principal's duties as a trustee for someone else. As I mentioned before, under an enduring power of attorney or even general power of attorney, the attorney cannot make health and lifestyle decisions. It's only financial and legal decisions. To make health and lifestyle decisions, one needs an appointment of enduring guardian. Registration of an enduring power of attorney, it's only necessary for the enduring power of attorney to be registered if the attorney finds themselves in the situation of having to deal with the principal's real estate. So what tends to happen is that the enduring power of attorney is made, the original resides with your solicitor, it isn't registered at the time, come the time, then registration is proceeded with. People tend to adopt that plan of attack to avoid what the present registration fee with the Land Titles Office or the NSW Land and Property Information as it's known now. The fees currently, as of the 1st of July this year, are $103. There's nothing stopping the power of attorney immediately being registered, but most people do not proceed to registration until it becomes absolutely necessary. Now, cancellation. It is possible for, it's possible for an enduring power of attorney to be cancelled or revoked at any time prior to the principal, whilst ever the principal is of sound mind. Once the principal loses mental capacity, then it's not possible for it to be revoked. Whilst ever the principal does have mental capacity, it is possible for it to be revoked. So if you make an enduring power of attorney and then for some reason you think that the person you have appointed is no longer appropriate, then it's possible to revoke the power of attorney. So what I've done here is just to conclude, do it now, avoid a row. Do it now while one has mental capacity, because as soon as one loses mental capacity, then it's not possible. And avoid a row. Disregard it as a cheap, easy and practical step to plan for your future. And that is why I labelled my brief address, Powers of Attorney and Appointments of Enduring Guardian, improve your quality of life now and in the future. It improves your quality of life, I would suggest, now, because it means that you have attended to this very important issue, you've got it out of the way, you no longer have to worry about it. And it improves your quality of life in the future because it's in place, and come the time when other aspects of your quality of life may not be as good as they are now, then this is one thing that has been done and attended to and makes decision making come the time easier. Turning now to appointments of enduring guardian, I mentioned that powers of attorney do not enable whoever is appointed to make decisions for you for lifestyle and health decisions. This is the document that does. It is a document whereby someone who you appoint is legally appointed to make those decisions about where you might live, what sort of medical and care services you might receive, and what health care you will receive if admitted to hospital, and importantly, what decisions and medical intervention will be made at the stage of end of life. And it's possible in the document to set out what your wishes are with respect to that time of your life. Now, I'll just mention here, given that some of us have travelled from the ACT, in the ACT there is only one document, and this leads to some confusion. In the ACT, the enduring power of attorney does cover health and lifestyle decisions. But in New South Wales, it does not. If you are fortunate enough to have real estate in both the ACT and New South Wales, I would suggest to you that it would be well worth your while to make an enduring power of attorney in the ACT, which covers all aspects of one's affairs, financial, legal, health and lifestyle, and to also make one in New South Wales, an enduring power of attorney, and also an appointment of enduring guardian for New South Wales. Now, just in respect of fashion and trends, just very briefly, powers of attorney are a document that have been around and known about for some time. Appointments of enduring guardian are a document that are not as well known. Indeed, I'll show you some figures in a moment which indicate just that. What has focused people's attention on appointments of enduring guardian are the following. The ageing population and increasing numbers of Australians entering retirement age, superior medical care and a general increase in the standard of living leading to longer life expectancy, the increasing incidence of dementia as well as awareness of these diseases, and also the emergence of the retirement village industry and an institutional expectation that new residents must produce evidence that they have an enduring power of attorney and appointment of enduring guardian in place. Now, some of you may be familiar with the term advanced care directives and living wills. What's the difference between those and an appointment of enduring guardian? An appointment of an enduring guardian is a legally based document pursuant to specific legislation. Advanced care directives or living wills are not. And so there have been instances where advanced care directives or living wills have not been held or adhered to by doctors and hospitals. Having said that, there are instances where an advanced care directive or a living will has been taken to the courts and it has been determined that it should be followed or will be followed in a particular way. My suggestion to you is that if you have an advanced care directive or living will in place already, then move to having an appointment of enduring guardian in place, because why go to the stress and the delay of having to perhaps test an advanced care directive for its legal validity at the time, come the time. Now, earlier this year, Palliative Care Australia released the results of a survey that they did in May this year. And it was an online survey of 1,000 Australians who had recently lost a loved one. And what they found, that 56% of those surveyed had superannuation in place, 50% had a will in place, 27% had a file of important documents, only 19% had a power of attorney in place, 13% had a list of assets, 13% had none of the above, 10% had a funeral plan, and only 5% had an advanced care directive, and within the advanced care directive was also appointments of enduring guardian. So you've got to remember here that who is being surveyed? The people being surveyed are the people who have just lost a loved one, and it was not about what the deceased had in place, but rather what the loved one had in place themselves. And you'll just notice that only 5% of people had an advanced care directive or an appointment of enduring guardian, and indeed only 19% had a power of attorney. Wrapping up very quickly, when to make, again, make it now. make it whilst you have the capacity to do so, because once you lose that capacity, you can't, and the difficulties that are then faced by your loved ones to look after you and to ensure that everything's in place that needs to be becomes just, it can be extremely difficult. Again, as with a power of attorney who can be appointed an enduring guardian, has to be over 18 years and obviously able to assist the principal with medical and lifestyle decisions. It's usually a relative or a friend, and again, what most couples do is they appoint their spouse and then they appoint an adult child as a substitute. What can an enduring guardian do? They can make health and lifestyle decisions for the person who has made the appointment, such as where the person may live, what medical and care services are required, and what health care is received, and to provide consent to medical and dental treatment. Importantly, the enduring guardian will be the person with whom the medical authorities have discussions about end-of-life decisions. These can be set out in the document. If they are, and have been discussed by the principal and the enduring guardian at the time the document's been made, then it becomes much less stressful for the enduring guardian, the loved one, to be making those decisions come the time in the knowledge that it's what the principal wanted. And it also empowers the enduring guardian to deal with other loved ones who perhaps aren't familiar with the principal's wishes. And finally, just with respect to registration, it's not necessary for an appointment of enduring guardian to be registered like an enduring power of attorney. And with cancellation, just as with powers of attorney, it can be prior to you losing mental capacity, it can be cancelled at any time. So that's all that I'd like to say this morning. Thank you very much, other than to encourage you to think about this very, very seriously, and if you don't have them in place, get onto them straight away, and also to not only speak to perhaps people of the generation above you about putting them in place, think about putting them yourself, think about putting them in place yourself, and also the younger generation, because the younger generation these days, they're much more into extreme sports and they suffer more serious motor vehicle accidents. So I would submit that it's just as important for the younger generation to have these documents in place as it is for our generation and the generation above. Thanks very much indeed.